Hello everyone, and welcome to Uncivil Law. For today's case, we have a case from the Supreme Court of the State of Tennessee. This is the case of State of Tennessee versus Angela Hamm and David Hamm. In this case, Angela and David were in a relationship together. One of them was under probation for a criminal violation, and the other was not. The police came to investigate a drug-related incident, and they found evidence that was being admitted against both of them. The question is, was this evidence properly discovered against both of them, and is the evidence properly admissible against both of them? So let's read more about the facts of this case. In November 2013, a jury convicted the defendant Angela Hamm of manufacturing a controlled substance. The trial court ordered her to serve a 6-year sentence. The sentence was suspended, and she was placed on a supervised probation. Notably, the probation order included a warrantless search condition, which stated, "I agree to search without a warrant of my person, vehicle, property, or place of residence by any probation or parole officer or law enforcement officer at any time." These kinds of conditions are pretty typical of parole or probation. So as part of it, you're like in this kind of quasi status, right? We're going to give you a break. We're not going to actually put you in jail, but you're still under some sort of terms and conditions. And one of those conditions is we get to search you if we want to. Okay. Thereafter, Angela Hamm married David Hamm and moved into his home. Approximately 2 years later, Officer James Hall with the Sheriff's Department Drug Task Force received information from an informant that heavy players were trafficking methamphetamine in Glass, a community in Overton County. I just want to take special note that they're producing methamphetamine in a place called Glass. Wow. The informant, who had drug charges pending against her, volunteered information against certain drug traffickers bringing methamphetamine to the county from across the river. She did not indicate how she obtained the information, nor would she identify the traffickers by name. However, when specifically asked about David Hamm, the informant smiled and nodded. On November of 2015, Drug Task Force agents went to defendant's home to conduct a warrantless probation search pursuant to Angela Hamm's probation order. The agents assumed they had reasonable suspicion to conduct such a search based on the information they had gathered from the informant. The agents then entered the house through an unlocked side door and proceeded to perform a warrantless search of the residence, including defendant's shared bedroom. Therein, the agents found pills, glass pipes, methamphetamine, and scales. Both agents testified that prior to performing the search of defendant's home, they confirmed with local probation office that Angela Hamm was on probation, and the probation order subjected her to warrantless search. Conversely, both acknowledged that David Hamm was not on probation at the time. According to testimony, the agents were unaware defendants shared a bedroom until they came into the home. We granted the state's application for permission to appeal this case to consider whether law enforcement must have reasonable suspicion of a probationer's criminal wrongdoing to support search of probationer's residence under an agreed-to warrantless search condition. So Tennessee is being asked to decide what level of review, if any, is appropriate for a person under probation. So one could assume that you would just be the same standard as for anyone else. You'd have to have probable cause and a warrant, but other states have, of course, gone a different way. So Tennessee is being asked to consider this question. What level of review is necessary? What level of suspicion must an officer have? Do they have to get a warrant or not under these circumstances? So let's read on and see what Tennessee decides. In State versus Stanfield, this court recently considered whether reasonable suspicion must support a warrantless search of a parolee's residence. Relying on Sampson v. California and State versus Turner, we held the search of a defendant, Winston's residence, was constitutionally reasonable based upon Winston's status as a parolee, even though the officers neither had a search warrant nor sought to obtain a warrant prior to the search. So one state can, of course, look to the proceeding of another state to determine whether or not other states' law is persuasive on its own. And so here they're looking to California law, amongst others. They see California has adopted a certain standard and say, we'll take some of that, and they adopted that too. That's perfectly fine. That's how it's normally done. We now address, under Tennessee law, reasonable suspicion is required for law enforcement officers to conduct a warrantless search of probationer's residence. We noted in a case called Turner, this court adopted a rationale stating The United States Supreme Court has recognized that criminal conviction subjects the offender to a continuum of possible punishments ranging from solitary confinement in a maximum security facility to a few hours of mandatory community service. Offenders' place on this continuum alters what is reasonable for the purposes of the Fourth Amendment. For instance, incarcerated felons have no legitimate expectation of privacy in prison cells. So as the court is pointing out quite correctly, there's a whole range of possible options. We can sentence you to jail for the rest of your life, solitary confinement, the whole 9 yards, or we can give you a couple hours of solitary confinement or somewhere in between. So the Fourth Amendment, which itself talks about reasonableness, is going to be necessarily impacted by where you lie on this line. Makes sense. The court in Turner expressly held under both federal and Tennessee state constitutional protections a parole condition requiring that the parolee submit to warrantless searches is reasonable in light of parolee's significantly diminished privacy interests. In Stanfield, this court made clear that search of a parolee's residence could be constitutional without consideration of reasonable suspicion. While Stanfield is instructive on the matter at hand, it is not dispositive because the defendant in that case was on probation, not parole. On the continuum of possible punishments and reductions from freedoms, parolees occupy a place between incarcerated prisoners and probationers. So here again on the Fourth Amendment analysis, they're saying we can draw some broad categories, right? We have people who are not subject to continuing monitoring, to people under probation, to next people under parole, and next people who are actually incarcerated as broad categories. So what might go to one category doesn't necessarily go to another category because of differential treatment, because the Fourth Amendment requires reasonableness. It is undisputed that the Drug Task Force did not obtain a warrant prior to searching defendant's residence, but the officers were aware of her status as a probationer. We must next consider what degree of suspicion, if any, is necessary to support a warrantless search of probationer. In United States v. Knights, the United States Supreme Court considered the constitutionality of a search that was premised on probation condition requiring Knights to submit his person, property, place of residence, vehicle, personal effects to search at any time with or without a search warrant, warrant of arrest, or reasonable cause by a probation officer or law enforcement officer. The United States Supreme Court said, the state has a dual concern with a probationer. On one hand is the hope that he will successfully complete probation and be integrated back into the community. On the other is the concern, quite justified, that I'll be more likely to engage in criminal conduct than an ordinary member of the community. As such, stated the United States Supreme Court, the balance of these considerations requires no more than reasonable suspicion to conduct a search of probationer's house. Because the search at issue in Knights was supported by reasonable suspicion, the search passed Fourth Amendment muster. Accordingly, the court held the warrantless search of Knights was supported. Of note, however, was a question left unanswered. The United States Supreme Court says, we, the United States Supreme Court, do not decide whether the probation condition is so diminished or completely eliminated that Knight's reasonable expectation of privacy or constituted consent that a search by law enforcement officer without any individualized suspicion would have satisfied the reasonableness requirement of the Fourth Amendment. The terms of the probation condition permit of such a search, but we need not address the constitutionality of suspicionless search because the search in this case was supported by reasonable suspicion. So in the case the United States Supreme Court took, they had a provision that read very much like the one we do here. We can search you at any time for any reason with or without cause. However, in that actual case, they did actually have reasonable suspicion. So the United States Supreme Court said, well, under these circumstances, reasonable suspicion, which you actually have, is enough. And so we're going to duck the question of whether or not you needed less or not. You had enough. Whether you needed less, we're not going to answer that. Someone else will figure it out. Well, we're in exactly that situation now. Someone else now has to figure it out. Is less enough or not? That's the question. Railway Hacker asks, would it be cruel and unusual to consent to cavity searches for years to come? Yes, quite possibly, and the court is going to get into that. Even where probable cause is not needed, they're still going to analyze it under reasonableness under the circumstances. So, they're going to say whether it was reasonable, notwithstanding the consent. So there does seem to be some implications that even if you gave consent to such a thing, that it may not be reasonable in all circumstances. So we'll get a little bit more to that as we go on. Of course, that would also depend on the exact nature of the crime and criminal offender. It would also depend on the specific facts. One could probably concoct some situation of some sort of person where ongoing regular cavity searches were somehow required. I'm hard pressed to come up with an example off the top of my head, but we're all creative people. I'm sure we can come up with something. But let's press on with the case. States have differing standards with regard to the distinction between parolees and probationers' expectations of privacy, and thus the level of suspicion required to support a warrantless search in every case. And here the Tennessee court previews some of the laws that relates to other states. For example, they talk about Vermont, 2016. Reasonable suspicion is still required in Vermont for searches for probationers. They cite Virginia, 2014. Rejecting a probation condition extending to suspicionless searches for purely investigative reasons, noting Sampson made distinction between parolees and probationers, and citing Indiana, 2015. While the facts that Sampson involved a parolee, not a probationer, and the Sampson court made a point of distinguishing, despite the differences on continuum, we nevertheless find they are shared to equivalent understandings. So here the Tennessee court is analyzing some of its sister states as they've analyzed this question as it relates to probationers and parolees, what distinction, if any, and what standard is required as they analyze what the rules should be for Tennessee. Let's read on. Under consideration of the United States Supreme Court opinions, the Sixth Circuit Court of Appeals decision in Tesser, the varying opinions from other federal courts and states, and our decisions, we acknowledge the state's substantial interest in supervising probationers as well as parolees warrants privacy intrusions that would otherwise not be tolerated. Therefore, we hold that a probation search, conditions that permits a search without warrant of a probation's person's vehicle, property, or place of residence of any time do not require law enforcement to have reasonable suspicion. So here Tennessee is departing from at least some of its fellow states in saying that reasonable suspicion is not required. This consent can be given at any time with or without reasonable suspicion, with or without probable cause, and with or without a warrant. That's Tennessee's judgment on the issue, and as they noted, other courts have disagreed. With that out of the way, the court is next going to analyze as to the issue of reasonableness. Under the totality of the circumstances, was this search reasonable? Because reasonableness is always required. Let's see what the court has to say. A probationer's home, like anyone else's, is protected by the Fourth Amendment requirement that searches be reasonable. Here, the record demonstrates the search was constitutionally reasonable. Officers Hall and Yates were aware of the probation status and conducted a search based on what they deemed to be credible information to determine whether she was engaged in drug activity, a valid law enforcement concern. The officers arrived during the home during daylight hours, not during the night. There is no evidence in the record that suggests the officers were acting in an arbitrary manner. The record is devoid of any proof that they sought to cause the defendants any harm. They acted out of personal animosity, or the search was one of a pattern of repetitive searches while the defendant was at work or asleep. So even where no probable cause, no reasonable suspicion is required, we're still going to require it to be reasonable based on the circumstances. And under the circumstances here, it appears to be reasonable, based on all the facts as just discussed. Makes sense to me. Accordingly, considering the totality of the circumstances, the search of defendant's bedroom was clearly permissible. Well, that takes care of the person who had a probation status. But what about the other person in the home? What about that of David Hamm? David Hamm wasn't under a probation status, and it's his home too. In fact, principally his home as we understand it. So was the search permitted under these circumstances? Let's read on. We next address the trial court's decision to grant defendant David Hamm's motion to suppress. As we stated above, the defendants shared a bedroom within the residence, thus their legal statuses intertwine. Therefore, it's necessary to consider whether the doctrine of common authority applies to searches of belongings that were found within the bedroom but that clearly belonged to David. We discussed this in a related case during this exact same stream, as a matter of fact. The idea of common shared ownership over things. If you have common right of possession of common things, then each has the rights of the other when it comes to allowing searches or otherwise. So if this is a common bedroom and the police have the right to search her bedroom, they have the right to search his bedroom because they're one and the same. In Stanfield, we expressly adopted a doctrine of common authority as it applies to parole searches of areas over a residence over which a parolee has a common authority. We conclude the privacy intrusion upon an individual sharing a bedroom, that is, an area with common authority, with a probationer is not so invasive it would not be tolerated under the Fourth Amendment. Nevertheless, the government bears the burden of proving the common authority doctrine applies. The state has satisfied its burden in this case. The officers believed the defendants to either be married or seeing each other, and Angela Hamm had been living in David Hamm's home for quite some time. As an aside, by way of standard Fourth Amendment jurisprudence, although the court does not analyze it here, the standard usually is overnight guest as to when Fourth Amendment issues apply in a home. So if she was an overnight guest in that bedroom, then that would allow Fourth Amendment for as long as she was a guest in that same bedroom. So there's no particular continuity requirement. As long as she's currently a guest and she has been an overnight guest, then the Fourth Amendment would give her rights in that. And of course, her rights have been waived. So that's kind of where we are. So, by my analysis, if she had been an overnight guest, then that would be the analysis there, but the court doesn't say that here. Angela Hamm and David Hamm shared a bedroom in the residence. Thus, by virtue of the doctrine of common authority, let's try that again without the voice cracking. Thus, by virtue of the doctrine of common authority, law enforcement officers did not err in searching and seizing all items of contraband found in a shared room. The trial court, therefore, erred in suppressing the evidence against David Hamm. Well, that is the end of this case. This has been the state of Tennessee versus Angela Hamm and David Hamm. In this case, we learned that in Tennessee, Angela Hamm had been prior convicted, and she had probation. As part of her probation convictions, she agreed to allow herself to be searched or her property be searched without a warrant. And that's exactly what the police did. The state of Tennessee had to consider whether or not this consent was valid. They determined it was valid, and therefore the evidence could be brought against her because in the totality of the circumstances, the search was reasonable. And because she had shared ownership in the bedroom, the right to search her bedroom included the right to search his bedroom, and so the evidence can be submitted for both. So both can be charged, both can be convicted, and that is the end of this case.